and certain restrictions are there. If you can keep it. Now let's move to Pakistan. You see how they have structured it in terms of the criteria for appointment. No person shall, particularly having regard to the disturbing trend we found, how it has become a license, how they think there are no checks and balances. Nobody can question them because there is no law. There is nothing is like you said. We are talking about the silences of the Constitution.
I see that. How the one well-settled principle that an original provision of the Constitution cannot be put to challenge. And the well-mentioned Prashant Bhushan in his submission says, declare the appointment procedure as unconstitutional. Court will not do that.
These are some of the laws, relating to Election Commission. And we thought that, we have to look closer in our neighborhood as well. We are going to England. We thought we should start with Sri Lanka, for example. And so we,
no, if your lordship,
we have made a, we just expect that you will give it back to us.
Yeah, we will.
And also occasion to look in
the government property so that we
No.
So we got one more actually, we can just. So what we've done is, if you see the first is Sri Lanka, it says sub-article 3, it's incorporated in the Constitution, Article 103, sub-article 3. They go as far as, prohibiting. No person shall be appointed as a member of the commission or continue to hold as a member if he is or become a member of the parliament, provincial economy, local authority, or is appointed as a judicial officer or a public officer. Okay, that is one thing. Then you have Nepal. See how far they have gone. They say that at 245(2), the President shall, on the recommendation of the Constitutional Council, appoint the Chief Election Commissioner and the Election Commission. So they have made that. Now let's go over to Bangladesh. There, of course, it is closely, they have this almost same subject to provision. I think this is modeled on our constitution, and certain restrictions are there. If you can keep it. Now let's move to Pakistan. You see how they have structured it in terms of the criteria for appointment. No person shall be appointed commissioner unless he has been a judge of the Supreme Court, or has been a senior civil servant, or is a technocrat and is not more than 68 years. Now, they have taken pains to also articulate what is meant by a senior civil servant, a technocrat, etc. And then the Prime Minister shall, in consultation with the leader of the opposition in the National Assembly, forward 3 names for appointment to the Commissioner to a parliamentary committee for hearing and confirmation of any one person. And various provisions are there which we sort of commend for your consideration. Now, if you come to the next one, you'll find
UK.
That is another model you'll get there. And if you come to the US, the last one, the Federal Election Commission, so it goes in for the Senate confirmation. And there you see at 3, Arabic 3, members shall be chosen on the basis of their experience, integrity, impartiality, good judgment, and member, etc., etc. And various other restrictions are put. So we just thought that we should place this for your consideration. You want us to remain behind other countries, particularly having regard to the disturbing trend we found, how it has become a license, how they think there are no checks and balances. Nobody can question them because there is no law. There is nothing is like you said. We are talking about the silences of the Constitution.
I see that.
How the silences of the Constitution are being exploited. There is no law, like you said. I mean, there is no law. There is no check. Nothing can be done legally. Yes, they are right.
first blush, having seen these, every one of these constitutions mentions mandatory using the term of the Chief Election Commissioner and Election Commissioner. It also provides for removal to be on par for both the CEC as well as the Election Commissioner. I just thought, I mean, we're very grateful for this level of
No, much
research
will
and
turn-
have done, which we
It
could have
will
done.
turn on, not on the lexical meaning of may or shall. It depends on the context in which it is used, and then how an authority perceives the nature of the duty. Therefore, we did not go on those lines. I've also seen many of these. I've
You would have seen
looked
it.
into
Of
many of
course.
these
We wanted
constitutions
to just place it.
and,
before you.
and for instance, the Canadian electoral reform.
That's right. That's right.
The Constitutional Assembly had looked into that. So, at some broad and except this very detailed,
And
I've also.
one
Your
more
Lordship.
last observation so that you can just think of it when you reply. See, in the Constituent Assembly debate,
Yeah.
you notice actually the tide was turned by the member from Bombay. His name, I forget the name. He would say that the Election Commission is contemplated as an agent, as a part of the government.
Correct.
And what is his name?
I'll just pick it up.
Munshi came. So Professor Munshi remarks. He said, "Let there be a law, let it be worked out, and it can be a part of the government. It should not be divorced entirely. It can't be given independence because all the resources are being provided by the state. So it is necessarily dependent upon the state.
Yes.
It cannot have an independent role. He goes to even say it cannot become a super government.
Yes.
So those, the point is at the time when the founding fathers, because when you talk about expounding the Constitution, as you know, there are 4 theories.
Right.
Which the US Constitution, the originalist theory, which is what the founding fathers had in their minds at that time. And, future generations are hidebound, they can't go behind it.
Yes.
Whether we should stick to the originalist theory, which is what some judges in the US Supreme Court, advocate, but whether we should do that in conditions peculiar to our country and knowing how things are, power when it is obtained, how it is used.
I know there'll always
2004 to 2020, I've given you statistics.
Yeah, absolutely. There'll always be a perspective from that point of view.
That's right. The point
peculiar.
is we have to deal with our conditions.
That's right.
Our men.
That's right. And while we enter into that.
Sorry, I mean we have taken.
No, certainly. I'm extremely grateful
So
for
that,
inviting me. And I've also done some little exercise, but not fully as your Lordships have done. I called for some information and then looked into it. And one may throw some light on it. After probably I'll get some more instructions on it. How to help
go ahead.
Lordships. But before I broadly looking at pre-1991 and post-1991, can be broadly classified. Why it might have happened like this is too difficult to guess. But then probably one has to dig into the archives, what happened 8 years, long years. But now that the law is there after 1991, how do you go about working under the law 6 years? Whether it is obligatory, can you curtail it? Will you not look into it more closely and say, yes, I am bound by it? All those questions are very important. And certainly one cannot shy away from those questions.
Yeah.
I'll try to, but broadly speaking, when I looked into this, my first question was, what is the position in other countries? So I tried to look into it. If the constitutions in other countries, if the constitutions themselves proceeded on certain lines, then we are talking about a constitutional scheme. So a comparison between two constitutional schemes may or may not be too appropriate, except where distinct constitutional schemes notwithstanding, the working under these constitutional schemes are given some lessons, useful, which can be borrowed. That's how I look at it. So instead of getting into those very narrow dividing lines. But if the Constitution of India says 324B shall be like this, and it also provides a certain understanding that over a period of time, whenever the time may come, Parliament may enact a law to deal with certain matters or subjects under 324B B1, 2, 3, etc. Then the question that may arise for consideration is whether the Parliament has done something under the Constitution is one question. Whether the other parts of 324(1) to be the place of the President, how the President will exercise her or his discretion, pointing, so and so, they are parts of the Constitution. It is one well-settled principle that an original provision of the Constitution cannot be put to challenge. And Violation Prashant Bhushan in his submission says, declare the appointment procedure as unconstitutional. Court will not do that. An amendment to the Constitution because of 368 powers, all those basic structure, of course, that will certainly be a matter for consideration. Therefore, a very important distinction in the original provision of the Constitution, as it stands, the court will not strike it down. But where it becomes necessary, that's why in the context of fundamental rights, well, let me put it like this. We keep saying fundamental rights are an integral part of the Constitution. Part 3 and Part 4 are the two chariots, wheels of the chariot and the constraint, etc. But I suppose if fundamental rights permeate the entire constitutional scheme, let us proceed on that footing, so that we have a very comprehensive view of the Constitution itself. Today, courtesy after 1978, state of Karnataka, Rajasthan, although Bommai has taken the leap forward. And thereafter, even in Article 311C, the President's decision-making process in respect of armed forces can also be subject to scrutiny. So what are those matters that are open to scrutiny are all on the basis of fundamental rights and certain scheme of the Constitution which will advance the fair movement of the Constitution towards a higher social order. That's how one can look at it. But that would again not mean that by process of interpretation or a meaning given to words in the Constitution, one can enhance the quality of the working of the Constitution, raise it to higher levels of working. That is done. But to come back if the original provision of a Constitution has certain issues, then will it not be a matter for a parliamentary debate? Will not be a matter for a broader social democratic debate as to whether this provision should remain as it is? So that line of distinction, I think, is very important. So that's why I would like to answer both these questions a little later. Now, I was reading a book on administrative law in US. A very interesting observation made. I've tried to read it and then go further with my silence of the Constitution.
Yes.
This is how the author puts it. I've tried to kind of paraphrase it. The subtle problems of modern policy making are more akin to automobile design. I'll take a printout and give it out. The subtle problems of modern policy making are more akin to automobile design or composition of a symphony. It's not that. No, I'm not reading. I'm just reading it from my hand. I'll just give it to you. I'll just hand it over.
What is the nature of what is the book?
It's a administrative law by Christopher Redley. I'll hand it over. Subtle problems of modern policy making are more akin to automobile design or composition of a symphony. The artistry is in the complete vision and in the integration of subsidiary skills. No natural law assures us that a collection of skilled musicians will produce beautiful music. And no natural law of management assures us that a collection of experts will produce worthy administration. That's where all these problems arise. The whole is neither more nor less than the sum of the parts. But why I wanted to read it out is that we are looking at the design of the Constitution in certain parts where we think is there something originally lacking in the vision, or it was not the original lack of the vision, but a later point of time in the understanding of the importance of the latent designs in the vision, and therefore there is something which is deficient in the understanding and the working of the Constitution. So if you're looking at the later part, deficiencies and in the understanding and the working of the Constitution, and therefore there is something which is wanting. That's why we all entered in the question of a vacuum gap and things like that. Probably I would like to pose a larger question. Apropos what this person told me. We will take your lordships from Vineet Narayan onwards. And these are all areas where we are concerned with either the realization of fundamental rights have some issue, or there's some disability imposed, or the infringement is indirect. So on and so forth. One can probably multiply how, in the context of realization of fundamental rights, there is an issue. And that the court, therefore, is anxiety and concern to ensure, as a sentinel on the qui-vive, that fundamental rights shall anyway, in any manner whatsoever, impediment shall be, obstacle shall be removed and shall be facilitated, realization made possible. It's in those areas where, not that the court would imagine a vacuum, but there is an actual concrete situation when the court comprehends and says, yes, let me look at it and how do we handle the situation. Therefore, there's always a gap between in law and life. Holmes' famous statement is logic, experience, but Chief Justice Israel Barak and said, no, it is both. It's both logic and experience. I think that's correct. So that's why you're talking about the experience and also the logic behind it. So having said that, let me just take a quickly and then go back to my. This book was written in the context of the unwritten Constitution of England. There are a lot of constitutional conventions which occupied parliamentary debates and how courts should look at. This should not be thought of as empty constitutional gaps to be filled in through the normal course of legal interpretation and political development. Neither should they be seen as constitutional deals by which particular issues are attended through a conscious form of mutual accommodation between contending parties, nor as conventions demarcating expected behavior through informal but generally obligatory agreements. On the contrary, abeyance should be seen as akin to barely sensed disjunction lodged so deeply within Constitution that far from being susceptible to orderly compromise, they can only be assimilated by an intuitive social acquiescence in the incompleteness of a constitution, by a common reluctance to press the logic of arguments and political authority to conclusive position, and by an instinctive inhibition to objecting to what is persistently omitted from the constitutional agenda. There are 3 or 4 thoughts which are suggested here. The last part of it is that by a common reluctance to press the logic of argument on political authority to conclusive position, and by an instinctive inhibition to objecting to what is persistently omitted from the constitutional agenda. That's why we go back to the original constitution and we look at it as something which is taken, which is given. So it's one thing to say what the constitution says, and it's a different thing to say what the constitution means. And what the constitution means will often happen when the court is called upon to engage on, most importantly, on the rights of people. While it's certainly an important value in itself that an independent election authority is a fulcrum for free and fair elections, citizens' participation in a free and fair election, the enabling element, etc., all that is well taken. I don't think we need to have any debate on that at all. But in what context the court will be called upon to say, what is that you have failed to perceive? That's the only question that brings